Your Honour, the situation is this. There has been 106 charges laid against my client. My client is a Torres Strait Islander juvenile born on the 29th of June 2000 and was charged by the police, taken into custody and questioned at the scene of the locus in quo. He was arrested, taken back to the police station where further questioning took place. The first argument is this. From the evidence relied upon from the first interview, nothing's been recorded. No notes have been made by the police officers. They have just simply taken what they say my client said at the scene and put it into a statement. That is the crux of the first argument. The second argument is this. The police take my client after they have admissions from him into an unmarked police car where a police officer was in the back while one was driving in the front, both in plain clothes, while my client is still under arrest. At this point in time, my client's parent or guardian have not been contacted, and that's in breach of the Police Powers and Responsibility Act. My client was driven around the suburbs and was asked questions such as these. Did you break into this house? Yes, I think so. Did you break into this house? Yes, I think so. Did you break into this house? I'm not sure. I can't remember. And this goes on 106 times for all 106 charges. That's the basis of the case against my client. From there, the police officers drove back to the police station, took my client into an interview room, and still, at this point, did not even think to contact a parent or guardian, clearly in breach of the long-standing rules since the Fitzgerald inquiry. My client is then put into an interview room, still not advised that a parent or guardian will be contacted for support. Some independent person, who we don't even know, is present during the interview, where full admissions were made by my client to the police officers. What my client tells me is that this support person tells my client prior to the interview, just do the right thing and tell the truth to the police officers. Something of that nature. And you'll find that, Your Honour, in my written submission at page 5, line 20. Your Honour, there is no question that police at this point would have been well aware that they were dealing with a juvenile with strict legislative requirements that must be met. Not should be met, but must be met. Can I refer, Your Honour, to section 421 of the Police Powers and Responsibilities Act, which cannot be clearer. A police officer wants to question a relevant person and the police officer reasonably suspects the person is a child, which the police had plenty of reason to suspect at this point, as my client had been in custody for some time, and it is inherently obvious. Subsection 2, the officer must not question the child unless before questioning starts, the police officer has allowed the child to speak to a support person chosen by the child, in circumstances where the conversation will not be overheard. Now this has happened, the police have done that, but my client hasn't had the opportunity to decide who he wants as the support person, whether it be his mother, father, grandfather, grandmother, anyone in his family tree. In contravention of section 421 of the Police Powers and Responsibilities Act, sections in the Police Powers and Responsibility Regulations, namely section 25, come into play. The police knew my client is a juvenile. The police should have been on the phone finding out who my client's parents are, who then could have directed my client to not even talk to the police. I bring your attention now, Your Honour, to section 5 of the Police Powers and Responsibilities Act and the purpose of this act. Subsection E in particular, to ensure fairness and to protect the rights of persons against whom police officers exercise powers under the Act. My client should have had the opportunity to have a support person present at the interview of his choosing. My final point is in regards to the discretion to exclude evidence based on the Bunning and Cross principle, where the evidence would not be admissible. As the evidence collected by police is in breach of both the Police Powers and Responsibility Act and the Police Powers and Responsibility Regulations I ask you to consider this discretion as the evidence was collected improperly. Thank you, Your Honour.